the competency strategy that changed everything. 3 defendants, 3 competency evaluations, 1 family. And now one question is changing the entire direction of Ohio's House of Horrors case. When Gary Siders Jr. first asked the court for a mental competency evaluation, many people believed it was simply an individual legal decision. Competency evaluations are not uncommon in serious criminal cases. Courts must determine whether a defendant understands the charges, can communicate with an attorney, and is capable of participating in their own defense. At the time, many observers assumed the request applied only to Gary Jr., but then something unexpected happened. Gary Siders Sr. made the same request. Soon after, Christina Siders also asked the court for a competency evaluation. 3 separate defendants, 3 separate requests, all from the same family. Almost immediately, legal experts and people following the case began asking whether this was more than a coincidence. Could this be a coordinated legal strategy? Or are all 3 defendants genuinely unable to stand trial? That question has now become one of the biggest legal issues surrounding one of Ohio's most disturbing child abuse investigations. Authorities allege that 16 children were found living in horrific conditions inside a rural property in Vinton County, Ohio. Investigators described children suffering from severe neglect. Some reportedly had little or no education. Others allegedly lacked proper medical care. Officials say the conditions had continued for years before law enforcement finally entered the property. The 4 adult defendants now face multiple felony child endangerment charges. If convicted, they could face decades in prison. But before any jury ever hears the evidence, another legal battle must take place. The court first has to determine whether the defendants are mentally competent to face trial. Many people confuse competency with an insanity defense. They are not the same thing. A competency evaluation does not determine whether someone was mentally ill when the alleged crimes occurred. Instead, it focuses on one question. Can the defendant understand the legal process today? Can they understand the charges? Can they assist their attorney? Can they make informed decisions during the trial? If the answer is no, the criminal case usually cannot move forward until competency is restored. That is why these recent court filings have attracted so much attention. The timing is difficult to ignore. One defendant requested an evaluation, then another, now a third. It has led many legal observers to wonder whether the defense teams are working from the same strategy. If so, what exactly are they hoping to accomplish? Could these evaluations delay one of Ohio's highest profile child abuse prosecutions? Could they change the order in which the defendants are tried? And perhaps the biggest question of all, will Elizabeth Siders become the 4th member of the family to request a competency evaluation? Right now, no such request has been publicly filed. But after seeing 3 nearly identical legal moves, many people are wondering whether another filing is only a matter of time. If that happens, every adult charged in this case would have asked the court to examine their mental competency before trial. That would be an extraordinary development. And it would raise even more questions about what the defense strategy really is. In the next part, we will examine whether these competency evaluations could actually delay the trial, why defense attorneys often request them, and whether this legal strategy has worked in other major criminal cases. Is this a defense strategy or a genuine mental health concern? As more competency requests were filed, one question quickly became impossible to ignore. Why are multiple members of the same family making the exact same legal move? Defense attorneys rarely discuss their strategy in public. Because of that, no one outside the courtroom knows exactly why these motions were filed. But experienced criminal defense lawyers generally request competency evaluations for several possible reasons. The first is the most straightforward. They may genuinely believe their client is unable to understand the legal proceedings. The law requires every defendant to be mentally capable of participating in their own defense. If there is reasonable doubt about that ability, the attorney has an ethical duty to bring the issue before the court. A competency evaluation protects the defendant's constitutional rights. The second possibility is more strategic. Competency evaluations take time. Once the court grants the request, mental health professionals must examine the defendant, prepare reports, and present their findings. Court hearings may be postponed while that process is completed. In a large criminal case involving multiple defendants, even one competency evaluation can affect the overall schedule. Now imagine 3 separate evaluations happening at the same time. The legal process becomes much more complicated. That does not automatically mean anyone is trying to delay the case. Complex criminal proceedings often require additional time for legitimate legal reasons. However, prosecutors also understand that delays can affect witnesses, evidence preparation, and public attention. Every additional month changes the dynamics of a major criminal prosecution. That is why competency hearings are taken so seriously. Another reason defense attorneys sometimes request evaluations is to establish a complete record before trial. If a defendant is later convicted, appellate courts may review whether that person was mentally competent throughout the legal proceedings. Failing to address competency concerns early can create significant legal issues later. From the defense perspective, requesting an evaluation may reduce the risk of future appeals based on competency. Still, many people following this case believe something larger may be happening. The pattern has become difficult to ignore. First Gary Siders Jr., then Gary Siders Sr., now Christina Siders. Each request raises the same legal question before any jury hears the evidence. Whether planned or not, the result is the same. The focus of the case has shifted away from the allegations themselves and toward the defendant's mental condition. That shift has created intense public debate. Some people believe the requests represent a legitimate legal safeguard. Others believe they are simply another way to slow the prosecution. At this point, there is no public evidence proving either conclusion. The court will ultimately decide whether each defendant is competent based on independent medical evaluations, not public opinion. One important fact is often misunderstood. Being found incompetent does not end a criminal case. It also does not mean the defendant is found innocent. Instead, the criminal proceedings are temporarily paused while treatment is provided to restore competency, if doctors believe recovery is possible. Only after competency is restored can the criminal trial continue. If doctors determine that restoration is unlikely, the legal process becomes much more complicated and depends on Ohio law and the specific findings in each case. For prosecutors, these evaluations create another challenge. Instead of preparing immediately for trial, they may now have to wait for several independent psychiatric evaluations before presenting evidence before a jury. Meanwhile, investigators continue reviewing thousands of pages of evidence gathered during the investigation. Every court filing, every expert report, and every hearing now becomes another piece of a case already considered one of the largest child neglect investigations in Ohio's history. In the next part, we will examine what actually happens during a competency evaluation, whether defendants can successfully fake mental illness, and why forensic psychologists are trained to detect deception before reporting their conclusions to the court. Can defendants fake mental illness? One of the most common questions people have asked since these competency motions were filed is simple. Can someone pretend to be mentally incompetent just to avoid trial? It is a question that comes up in almost every major criminal case involving competency evaluations. The short answer is that forensic psychologists are trained to look for exactly that. A competency evaluation is very different from an ordinary medical appointment. The examiner is not there to treat the defendant. Their job is to answer a legal question for the court. Does this person understand the criminal charges? Do they understand the role of the judge, the prosecutor, the defense attorney, and the jury? Can they communicate with their lawyer? Can they make rational decisions about their own defense? The evaluation usually includes long clinical interviews. The defendant may be asked to explain the charges in their own words. They may be asked how a trial works. They may have to describe the possible consequences if they are convicted. Examiners also review medical records, jail records, prior psychiatric treatment, and behavior observed by correctional officers. Nothing is based on a single conversation. The evaluation looks at the entire picture. One reason these examinations are taken so seriously is because some defendants have attempted to exaggerate or fake mental illness in past criminal cases. Forensic psychologists know this. That is why they use scientifically developed assessment methods designed to identify inconsistent answers, exaggerated symptoms, and behavior that does not match genuine psychiatric disorders. Someone who claims to hear voices one day but behaves completely differently the next may raise concerns. A defendant who suddenly appears confused only during formal interviews but functions normally in everyday conversations may also receive closer examination. Examiners compare what they observe with medical history, documented behavior, and information from multiple independent sources. The goal is not to prove someone is lying. The goal is to determine whether the evidence supports genuine incompetence. That is why courts rely on trained forensic experts rather than public opinion. In the Ohio House of Horrors case, the results of these evaluations could significantly influence the timeline of the prosecution. If one defendant is found competent, that person's case may continue toward trial. If another defendant is found temporarily incompetent, the court may order treatment designed to restore competency before proceedings continue. Each defendant is evaluated individually. The court does not automatically reach the same conclusion simply because several family members requested evaluations. That point is especially important. Many people have asked whether the 3 competency requests mean all 3 defendants will receive the same ruling. The answer is no. Every evaluation is independent. Every report is based on that specific defendant's mental condition. One person may be found fully competent. Another may require treatment. A third may receive a completely different conclusion. The court considers each report separately before making its decision. Even so, the pattern remains remarkable. 3 members of the same family have now asked for competency evaluations before the case has reached trial. Whether that reflects genuine mental health concerns, careful legal planning, or a combination of both is something only the evidence will reveal. Until the evaluations are completed, no one can honestly predict how the judge will rule. But one thing is already clear. The legal battle over competency has become almost as important as the criminal charges themselves. And the decisions made during these hearings may determine when, or even how, one of Ohio's most disturbing child abuse cases finally reaches a jury. In the final part, we will examine the possible outcomes if all 3 defendants are found competent. What happens if 1 or more are ruled incompetent? Whether Elizabeth Siders could become the next family member to request an evaluation, and how these decisions could shape the future of the entire case. What happens if the entire family is found incompetent? As the court waits for the results of multiple competency evaluations, one question continues to dominate public discussion. What happens if every member of the family is found incompetent to stand trial? At first glance, that possibility sounds dramatic, but the legal reality is far more complex. Being found incompetent does not erase the criminal charges. It does not dismiss the indictment, and it does not mean the defendant has escaped responsibility. Instead, the criminal proceedings are placed on hold. The court's first priority becomes restoring the defendant's competency so the legal process can continue. Depending on the findings of mental health professionals, the defendant may receive psychiatric treatment, medication, counseling, or other services designed to help them understand the court process. After a period of treatment, doctors evaluate the defendant again. If competency has been restored, the criminal case resumes. The trial moves forward. The evidence is presented. The jury hears the facts. Only then can the court decide guilt or innocence. But another possibility also exists. If mental health experts conclude that a defendant is unlikely to regain competency within the time allowed by law, prosecutors in the court may have to consider other legal options. Those decisions depend on medical evidence, Ohio law, and the specific circumstances of each defendant. No 2 cases are exactly alike. That is why the upcoming evaluations are so important. They may determine not only when the trial begins, but also how the prosecution moves forward. There is another question that has attracted enormous attention. Will Elizabeth Siders also request a competency evaluation? As of now, no public court filing shows that she has done so. But after similar requests from Gary Siders Jr., Gary Siders Sr., and Christina Siders, many people are watching closely for any new legal filings. If Elizabeth were to make the same request, every adult charged in the case would have asked the court to examine their competency before trial. That would be an extraordinary situation in a case involving multiple defendants. Even then, each evaluation would remain independent. The court would not assume that every defendant should receive the same ruling. Each person's medical history, behavior, examination results, and ability to understand the legal process would be reviewed separately. For investigators, prosecutors, and the families of the 16 children, the waiting continues. The evidence collected during the investigation has not changed. The charges remain in place. What has changed is the legal path leading to trial. Instead of immediately presenting evidence before a jury, the court must first answer a different question. Are the defendants mentally capable of standing trial? Only after that question is resolved can one of Ohio's largest child neglect prosecutions move into its next phase. For now, the competency hearings have become the center of the case. Every new court filing is closely examined. Every ruling could affect the timeline, and every decision may shape what happens next. Whether these evaluations reflect genuine mental health concerns, a coordinated legal strategy, or a combination of both will ultimately be determined not by public opinion, but by independent medical experts in the court. Until those findings are complete, one thing remains certain. The Ohio House of Horrors case is no longer just about what investigators discovered inside that home. It is now also about whether the people accused of those crimes are legally able to answer for them in court. The next rulings may become one of the most significant turning points since the investigation first shocked the nation